If you own or plan to own property in Turkey, there is a question you need to answer now, not later. What happens to that property when you are gone? Turkish inheritance law works very differently from what most foreigners are used to, and getting this wrong can create real complications for your family. In this video, I'm breaking down exactly how Turkish inheritance law applies to foreign property owners in 2026, including statutory shares, wills, and how to avoid probate delays. Let's get into it. Before we go further, I want to talk directly to you for a moment. If you already own property here or you are planning to buy, I want you to know people just like you reach out to me every week with questions exactly like this one. I specialize in real estate and relocation services here in Antalya, and while I always recommend working with a qualified lawyer for the legal execution, I help clients understand the full picture and connect with the right legal support. If you want guidance on your specific situation, reach out to me directly through the information in the description box below. Now, let's get into the details. First, let's talk about the principle of reciprocity. Turkish inheritance law for foreigners is shaped heavily on something called the principle of reciprocity. Essentially, whether Turkish citizens have equivalent inheritance rights in your home country determines certain aspects of how you can hold and pass on Turkish real estate. This is a nuanced legal area, and it's exactly why generic advice online often falls short. Your specific nationality matters here. Second, statutory shares. You cannot disinherit everyone. One of the biggest surprises for foreign owners is that Turkish law includes mandatory statutory shares for certain legal heirs, typically spouses and children. This means you cannot simply will your entire property to one person if you have a spouse or children with a legal claim under Turkish law. Even if your home country allows full freedom of disposition, this catches a lot of people off guard. Third, notarized wills. Why they matter. A properly executed notarized Turkish will is one of the strongest tools available to clarify your wishes within the boundaries of statutory shares. Without one, your estate may default to Turkish STC rules, which distribute assets according to a fixed legal formula rather than your personal wishes. I strongly encourage every foreign property owner to have a Turkish will specifically covering their Turkish assets, separate from their will in their home country. Fourth, avoiding probate delays. Probate for foreign-owned property can become a slow, complicated process if the right documentation isn't in place in advance, particularly if heirs are located abroad and unfamiliar with the Turkish legal system. Having your title deed, notarized will, and translated documentation organized in advance can be the difference between a straightforward transfer and a process that drags on for months. Fifth, what documentation do you actually need? At minimum, your heirs will need your title deed, your notarized Turkish will, if one exists, your identification documents, and in many cases, a certificate of inheritance obtained either through a notary or the courts. If your home country's legal documents need to be used, they will typically require an apostille and certified Turkish translation. 6. Common misconceptions. The most common misconception is that a will from your home country automatically governs your Turkish property. It doesn't. Turkish immovable property is generally governed by Turkish law regardless of what your home country will says. This is exactly why a separate, properly executed Turkish will is so important. If you are still in the early stages of deciding whether to invest here, watch my next video on how to successfully launch a small service business as an expat in Antalya. It covers a lot of the same legal and bureaucratic groundwork you will need either way. See you in the next video.